Yeah. Okay.
I wasn't planning on telling a joke, but because I'm going to be on TV, I think it's absolutely necessary. It'll be a little more exciting tomorrow. I think all of you would have been dressed up, I assume. But a fella is in a bar in Newfoundland at 3 o'clock in the afternoon, and it's quiet. He's there all alone. He has a sip, and a little voice says, "My, that's a beautiful tie you have on." Looks around, doesn't see anybody. The little voice says, "Marvelous shoes, nice match for your suit." So he says to the bartender, "What's going on?" He says, "I'm here alone. Little voice is saying things that are really nice about me." Boy said, "By them are the peanuts." "The peanuts?" "Yes, boy, they're complimentary." We want to talk a little bit about accommodation here. Now, accommodation, specifically we're going to focus on family status. Family status is a definition in the Human Rights Code that is expanding virtually every time a case comes up. Now, in Ontario here, family status is described as being a parent or in a child relationship. But specifically, we really need to be asking a lot of questions in order to determine what the person's particular issues are before we decide what type of accommodation we can provide. And, you know, every day we run into people who have, let's say, a very closed mind with respect to rights of people. So we really do need to understand that people do have the right to have access to a service or a certain aspect of employment, specifically here, based on whatever their protected ground might be. So if they need something to assist them to meet the requirements of the job, then we are obligated as employers to do so. Now, as I say, we can restructure the job in many different ways. Sometimes it's a slight change. Somebody may have daycare issues, and they would like to come to work a half an hour later or leave a half an hour earlier. In most companies, that is something that we can accommodate. And again, accommodation is up to the point of undue hardship. People say, what does that mean? Well, for most successful businesses, you will not meet the test of undue hardship. It means you need to be flexible, and hopefully the needs of the organization will be met. But again, job restructuring is one of the easy ways to accommodate. Now, it may mean a different type of schedule. For people who celebrate religions where prayer is part of the day, then it may be to modify the schedules for breaks such that people can honor their religion during the workday. Telecommuting is getting a lot of attention these days, and we were speaking earlier this morning about someone who had an executive assistant who was in Calgary, and they worked here in Ontario. So whenever they had sessions, they would simply send things to their assistant. She would put those in the right process and document it and send it back. And people say, well, how does that work? Well, apparently the person's been doing it for years. It's really not a problem. So with all of the supports we have today on computers and email and everything else scanning, it can be an excellent temporary measure to accommodate someone who has special needs. Again, certainly if someone had a broken leg, particularly on the right leg, they may not be permitted to drive their car or ought not to, then it might be a very reasonable accommodation in that situation. This is where sometimes people get a little bit inflexible. They may not be interested in modifying the exact job that people do, but that may be very, very necessary, particularly where the disability may have some restriction to the person's ability to do the physical demands of the job. And people say to me, what is a disability? Well, a disability is a definition defined by a doctor. It could be anything from a diabetes situation to a physical ailment. But again, it's not self-diagnosis, it has to be confirmed by a doctor. And then, if there is a disability, then it goes from a responsibility to accommodate to an obligation under the Human Rights Code to do so. And where people are violating rights, we see a lot of attention with the Human Rights Tribunal where people will make a claim, and it can be an extensive process to try to defend a situation. And not only it's difficult in that situation, it can also be very damaging to your reputation in that if it goes through a full tribunal and there's a decision, that becomes public. So your hard-won reputation can certainly have a negative impact based on likely inflexibility at the onset of an issue.
Now, I was speaking briefly just this morning, but a client from the US asked the other day, how many leaves do you have in Ontario? I said, oh, we have 9 protected job leaves. Pardon? I mean, it used to be difficult years ago when I worked for an American firm to explain emergency leave, 10 unpaid days virtually without any explanation, because people were crafty. They said, oh, my child is sick or my wife is sick and there's no way to get an explanation for that, or my daycare is unavailable, I need to be away. Well, it got to the point where it became very ridiculous. At one of the large plants in the area, the downtime or the sick leave during March break one year was up to the point of 19%. Now that's ridiculous because I was at the plant for 7 or 8 years before that and we never had that kind of absence during March break. But they applied the emergency leave and said, I don't have daycare. Well, they slowed down the production of that plant because it couldn't run it without that many people away. That plant is no longer here in our area. So, I mean, when people get their idea of entitlement and take it to extremes, it can really have a negative long-term consequence. But there are many types of approved leaves, and there are 3 new leaves that come on board today. And I know people from outside our area have a hard time to understand that we now have such leaves as if there's a crime-related death or disappearance of a child, the leave may be up to 104 weeks. But again, all of the leaves that we talk about here are unpaid. Some of them may be eligible for EI benefits, depending on the type of leave and the length of time, et cetera, and whether the person has insurable weeks. But these are also the types of leaves that give a person an opportunity to deal with generally types of crises in their lives. So we need to look at making sure people are aware of such leaves. I mean, people even say to me, you even have a organ donor leave? I said, yes, that was something that came in a couple of years ago, and where someone is going to donate an organ to someone else, typically a relative, then there's also protected leaves in that regard. So the key is to really ask a lot of questions. And the essential aspect of accommodation is to work with the person. It's very unlikely that you're going to be able to come up with a perfect accommodation without a discussion. And it's really saying, what do you require? And then you look at your business requirements and the needs of the business and maybe the needs of the team to discuss what is the best option to fit both people's requirements here. And it really has to be, the more the person is involved, the better the outcome. Now, there are a couple of examples of family status accommodations. Sometimes people are very surprised by the outcome. Particularly this one attracted a lot of attention. The person, let's see here, I want to talk about the griever was an apprentice welder and a single mother with 2 children out in Alberta. And she'd recently posted and been promoted to a position which was 7 days on, 7 days off, with rotating tours of day and night shift. She worked 1 session of a night shift and requested that her shifts be altered to day shifts, straight days. Well, of course, everybody in the company at that point said, well, wait a second, you posted to the job, you knew fully well what the demands were, you were awarded that job ahead of other people. Why is it that you are now asking for straight days? Well, she said it's too expensive during the night shifts to pay for her children. Well, and neither of her children's fathers were offering any type of support for the children, and she'd not applied for any daycare subsidy. But the bottom line is, at the end of it all, in a review, she was entitled to accommodation because of her family status, even though there were other circumstances that seemed to imply that she knew full well what she was getting into. But again, that's really caused a lot of hubbub in a lot of companies' discussions because it seems a little unreasonable. But there are many examples. I mean, some are very simple. A person's coming back from maternity leave, and she contacted her employer and said she wouldn't be able to come back for 3 weeks at the end of her 1-year maternity and parental leave. And the boss said, no. He said, you're due back on that day. If you don't come back, then you're deemed to have been resigned. You have to deemed that you have resigned. And of course, she put a complaint in with the Human Rights Tribunal, and she was awarded $15,000 for injury to dignity and lost wages. Because again, if she's been off for 1 year, realistically, how difficult would it be for the employer to maintain the leave for another 3 weeks? Let's be honest, someone was being way too rigid, and that situation becomes unrealistic. There's another gentleman who had very high needs child with major disorder issues, and it conflicted her schedule, conflicted with her ability to take care of her child after school. And again, the company said no, they would not modify her schedule in any way. And quite frankly, they were found guilty to be, again, in violation of a person's rights. So there are many examples where people, gentlemen, many of us are in the baby boomer age. My wife is, but I'm not. Just kidding. She's not here, so it's pretty safe. But the gentleman was the sole caretaker of his disabled mother. And he did a lot of work from home, and then his employer decided that as an engineer he should be at the office. So he found that this was very, very difficult for him to manage, given that his mom was very dependent upon him, and he was required to be home at a moment's notice. And he was eventually terminated from his employment. Well, again, the company was found to be in violation of his rights. Again, it ought to have looked at special ways to accommodate the person's need to look after their mom in this situation. And many of us may be in a situation where our parents may need the assistance they provided us when we were young. So it's another example where there has to be some kind of flexibility applied by a reasonable employer in order to allow the person to continue access to, in this case, work, or it could be services or aspects of the employment. Has anybody been asked for accommodation on family status? It's becoming very common. Was it something that was quite reasonable, or was it a challenge for you to?
Oh, sorry, you know what, I was thinking something, it wasn't actually family status,
Yeah.
it was their own status.
Right. Yeah. Well, every day, as I say, it's not clearly defined, but it is basically anything that prohibits a person from potentially working a scheduled or their normal shift due to family demands. Now, this isn't the same as some of the other leaves we put up where a doctor's certificate is required to support or validate the time away. It may simply be based on a concern or a family issue. So sometimes it's hard to get documentation to support the family status. You certainly may ask for it in a polite way, but the key is to ask a lot of questions, try to determine whether your business is in a situation where you can be modify or be flexible to accommodate. Because the other thing about it is it could be you the very next day, which is what I say to people about any type of protection under the Human Rights Code. Any one of us could be requiring some type of flexibility in the future. Yes?
Are they required to use up their vacation time first in a situation? So if you had, 10 days vacation, and they asked for a leave for one of the, reasons, they have to give those 10 days?
Well, it depends on the company's policies, but many companies have policies that have a statement that says paid leave must be exercised or utilized prior to unpaid leave. But it's a good discussion. Now,
Put that in your handbook?
you can put that in the handbook, but again, you need to be flexible just in case. Somebody may have, let's say, a flight booked overseas. So, and then something comes up in the family where it requires a special consideration. So it's never in stone, but it is common for people to say, yes, let's use up the time that we provide, whether it's, as you say, vacation days, maybe it's personal days, maybe it's floater days, whatever you might term. Hopefully the person will see that those were provided for this kind of requirement as well. But again, but not locked in. I always say HR is sort of gray. You really need to ask a lot of questions and then interpret based on the circumstances.
Where does it come in between accommodation and frustrated contract?
Well, a frustration of contract, I'll give you an example of a frustration. And it's hard to hit that particular definition. If a person is off on long-term disability beyond the 24-month period where they've now met the test of disabled for any occupation, and you get a decision from the employee, their doctor, or perhaps from the benefit carrier that the person is not able to return to work, that could be deemed to be a frustration of the employment contract. Now, that's not the person's fault and it's not the company's fault. But in that situation, if you end the relationship, then the person in Ontario is entitled to employment standards termination pay. That's not the same across Canada, but here the person would be entitled to notice. And if your company has a payroll beyond 2.5 million and the person has service over 5 years, he or she would be entitled to severance as well. There was a situation at one of the casinos where a security officer was advised well in advance that he could not retain his job if he had a criminal record. It was part of the new rules with respect to that type of work. He could have applied for what am I thinking of, a waiver? No, trying to think. What's the term when you, pardon, absolutely, thank you. So he could have applied for a pardon, but he didn't take the time to do so. When the rules changed, he lost his job because the contract was frustrated because he was no longer legally allowed to do that job. The same thing, somebody may lose their license, and if they're a truck driver, that could be a frustration of employment. But that would be the example that would be used in that situation. Yeah. And frustration is a tough situation to achieve. It also is a situation where the legal opinion is that common law normally does not apply when it's a frustration of the employment contract. It would simply be the employment standards termination provisions. Mm-hmm.
John, in the insurance business, we have a lot of times where we're dealing in a disability management situation and the duty to accommodate. So we work with the employer to try and bring the employee back. You add the factor of there's a union situation involved, and now the seniority comes into play.
Right.
And where does the employer really sit when the fact is that the company can accommodate, but the seniority factor comes into play and you can't move that particular disabled employee into a position that they might be able to do. However, there's a member there that has more seniority.
Well, that's always fun because we talk to the union and human rights trump collective agreements. So if there is a medical accommodation, particularly if it's disability related, and sometimes we all know that the union is built on seniority. I mean, it's the whole focus of the collective agreement and the process. However, where somebody needs a special consideration, the union, and many are completely enlightened to this and say, look guys, I'm sorry, but this person has the right to that job in that position based on their limitations. But I've had some very interesting conversations with people say, absolutely not. And I'd say, well, as I say, human rights is allowing somebody access to a service based on their disability. And so it is, and then people say, well, they sometimes talk to me about reverse discrimination. There's no such thing. I mean, if somebody has a mobility issue and the employees are to come through a certain door, but there are stairs there, then the accommodation is to allow the person to come in perhaps another door that may have a ramp. You're not violating anybody's rights by having someone come in another door. You're allowing that person to make a meaningful contribution, and a lot of the accommodations are fairly reasonable to implement. But as I say, we've had some challenges, shall we say. But again, a lot of times the senior union people say, absolutely, let's look and see how we can work together. Yeah. Mm-hmm.
What are some of the things that you're seeing that people will do for childcare to help with people who have sick children or even maybe disabled children? What are some of the companies doing that is innovative and working?
Well, I think the key, well, there are some very large companies that can offer daycare on site. That's still fairly rare in our part of the world, but it is common in other parts of the world where a daycare is provided on site. Again, I think the opportunity for someone to work at home is a really key part of trying to accommodate that. But realistically, it's almost saying to the person, what would you like us to do? How can we help you be successful? And then looking at what their interpretation might be. A lot of times it may be a temporary move to a part-time or maybe 3 days a week to allow the person to attend to special medical appointments. And a lot of times these accommodations aren't forever. They are for a relatively short period of time during maybe intense medical review, or if there's some type of problem that hasn't been diagnosed. So sometimes we emphasize how difficult these things are, and they're not. There are other innovative ways. Sometimes it's job sharing. That can work very well for people. If there are two people who have needs to be away from work more than a full-time person would be. But it just depends on what the situation is. That's the real key. And again, I even with the AODA legislation, as the people say, 15% of our population has some type of disability, and that's growing. So the sooner people understand that their employees will have potentially either short-term or long-term challenges, the better off they'll be about finding a good mix where that person's experience and knowledge of the business can be applied in maybe a unique way. Yeah. Well, as I say, family status is going to be redefined as we go along, because there are going to be, and there are many different definitions of a family. As to say, outside of Ontario, family status is not necessarily defined in the other jurisdictions, although many jurisdictions will look to accommodate people, even if it isn't defined in their version of the Human Rights Code. And it's defined here, as I mentioned, as parent and child. But it could be in other areas where someone is the caregiver of their aunt, then they may very well be given special consideration as well. Depends on the situation. Mm-hmm.
Just going back to childcare at home. I've even heard cases where they're a smaller office, and where there would be a couple of small children, and the mother would have to take time off, and the issue is the father is also working, but there's no consideration sometimes that maybe dad has to also step up to the plate. Where sometimes that has, I've been asked, well, what would you recommend in that situation? And I know the duty to accommodate, and and yet, speaking to the woman, the employer would say, well, I'm the mom and I feel that I have to step in, but then 2 weeks later, there was an issue because grandma normally babysits and is going away on a holiday.
Right.
So it's the mother that has to stay home, not the father again. So, there's again a real frustration there.
Right.
And they love this employee. When she's there, and most of the time there's and usually I would say, is there a way that you can just accommodate her, or just let her know that, this is a small office, we understand, we just appreciate when, that the fact that your husband is also part of this family, and sometimes you have to be fair. It's just a matter of being fair.
That's right, but sometimes you have to say to the person, the times that you have been away this year are excessive. And they create an undue burden on other employees, or maybe really don't allow us to meet the needs of our clients, customers, etc. So not only could your spouse basically be considered, but other family members. So that's part of that discussion. Now again, some people may say, no, I do not want my spouse caring for the child based on whatever the challenge might be. But other people can say, realistically, you need to explore within your family group other options that may decrease the amount of time you're away here, because ultimately you need to meet the requirements of a full-time employee here.
And also upon hiring, letting them know, asking them, what do you do in a situation when you've got you've got young children, what would you do in that situation?
Well, we don't ask those questions. But, again, sometimes that people think that's a very reasonable question.
Yeah.
Do you have children? Are you going to be away a lot? Well, we're not permitted to ask that question.
Right.
So that would be
Because
delved.
between myself and the employer when we're speaking,
Yeah.
and I understand what you're
But I
saying.
know people who say, they say, well, first of all, I want to know, are you having children? Are you planning, and say, let's, and again, they say, well, I need to know, I'm running my business. I said, well, I understand what your needs are, but they are not reasonable underneath the, with respect to the human rights entitlements. But, that will have to be crossed once the person is hired. But again, people say to me all the time, well, I need to know this. I said, no. You need to know whether the person is qualified and educated for the job in which they're being hired. So focus your questions on skills, effort, and ability to do the job. Mhm.
I have a question. For the family accommodations, we have staff members had a maternity leave. When she come back, and she couldn't work every single day, so she worked 3 days a week. In this case, should I rewrite a contract between the employer and employee? Should we?
Now, at her request, did she ask for the job to be moved from full-time to part-time? I would absolutely create a new employment contract based on what now is new conditions of employment. Because under the rules or regulations, somebody returning from maternity or parental leave is entitled to go back to their old job or one that's similar if their old job isn't available. But if the person says, I don't want to go back or I'm not able to go back to full-time, I'd like to work part-time, then really it's whether you have a part-time job, first of all, available, and then B, if that's the case, it would be wise to document how you got to that process. So as per your request, we are pleased to modify your position to a part-time role, 3 days a week. Yeah.
What about the other situation is one person, it was a hygienist, and then she found she couldn't work 4 days in a row. So she said every time if there's 4 days, she wants to have 1 day in between, have a break. So it's a kind of accommodation. We agreed, so if it would be too much for her. So if she has 3 days, it's fine. Like 5 days a week, in between there's one break. Whole week, it will be fine. But if it's 4 days together, she needs 1 day off. In this case, what should we?
Well, if you're able to modify other people's schedules such that that doesn't occur, that's wonderful. But if a person is requiring a change in the schedule and they're basing it on a medical situation, they ought to have the doctor indicate exactly what their limitations are. And it may be that the strain or stress of working more than 2 days in a row is too much, but that should be defined by the doctor under workplace limitations and work restrictions, and then it would be accommodated based on their medical requirements. Now, if somebody just doesn't like working 4 days in a row, that is, again, perhaps not in keeping with what the requirements of the job are. So you really do need to ask the questions about what is the basis of your request. Now, it may be that it's quite flexible because you have hygienists who typically work part-time or as needed. So it can be done without any need for a medical review. Because I say to people, anything involved in a person's medical situation or their prescriptions is private and confidential. We have the right to know prognosis for return to work, but not diagnosis. And again, an American client phoned the other day and said, well, I got a note, but it doesn't say what's wrong with the person. I said, no. In Canada, that is considered, again, confidential information. And if there is a type of prescription being prescribed, we have no right to know what it is, but we have the right to know how it may affect the person's job. So in that case, I would provide a job description and say, the person has been away for, let's say, 3 months. First of all, I'd like to have a note indicating they're fit to return to full duties, or if they're not fit to return to full duties, if it's partial duties, I may go to a FAF, a functional abilities form, to help the doctor translate that confidential medical into something that applies to the job. And again, if they're taking a prescription, I'd like the doctor to signify that that prescription will not have a negative impact on the person's work, particularly if they operate any type of equipment. And of course, that goes to other policies about drugs and alcohol in the workplace. Because again, people talk about illicit drugs. I said, no, you need to talk about, you want to make sure that people are not using prescribed drugs for which they weren't prescribed. Because that's also, unfortunately, one of the issues in our work environments as well. And of course, with medical marijuana being more and more prevalent these days, we need to talk about that situation as well. And that doesn't mean there can be other options that people may utilize during their workday, such that they're not smoking a joint at noon hour in front of all the other employees and then going into work. Because again, the whole idea is our focus has to be on health and safety. And there has to be some flexibility on both parties to make sure that the person can accommodate what might be a very serious pain issue, but also the requirements and demands of the job. Okay. Any other questions? Again, I'm sorry there isn't a definitive answer for everything on workplace accommodation, but it really is about being open-minded and asking questions and trying to work with the person so that their talents can be best used based on their particular situation at the time. And a lot of these accommodations are fairly short-term. And again, we are expected to be compassionate and benevolent, particularly when people have special needs. Okay. I thank you.
Very much, John.
Thank you.